Hi guys, this is Ishita, the legal intern at LEXCLIQ. Today I'm gonna tell you all about the regulations of FCRA contribution. It is in news recently. Why? Recently, the Ministry of Home Affairs issued new regulation guidelines to banks under Foreign Contribution Regulation Act 2020. It states that donation received in Indian rupee by non-governmental organizations and associations from any foreign source should be treated as foreign contribution. About the new guidelines, widening the scope of foreign contribution. Under the issued regulation, donation given in Indian rupees by any foreign or foreigner source, including foreigners of Indian origin like overseas citizens of India or person of India origin cardholders, should also be treated as foreign contributors, meeting the standards of FTAF. The guidelines mandate the good practices should be followed by NGOs in accordance with the standards of Global Financial Watchdog Financial Action Task Force. It asked NGOs to inform the ministry about the suspicious activities of any donor or recipient and take due diligence of its employees at the time of recruitment. Existing rules, mandatory reporting by banks. All banks have to report the receipt of utilization of any foreign contribution or by any NGO, an association or person to the central government within 48 hours, whether or not they are registered or granted prior permission under the Foreign Contribution Regulation Act 2010. Prescribed banking channels. In September 2020, the Foreign Contribution Regulation Amendment Bill 2020 was passed by the Parliament, a provision that it makes it mandatory for all the NGOs to receive foreign funds in a designated bank account at the SBI's New Delhi branch was inserted. All NGOs seeking foreign donations have to open a designated FCRA account at the SBI branch or link their existing account to it. Reasons for the FCRA regulation. The annual inflow of foreign contribution has almost doubled between the years 2010 and 2019, but many recipients of foreign contribution are being now utilized the same for the purpose for which they were registered or granted prior permission under the amendment provisions of the FCRA 2010. Recently, the Union Home Ministry has suspended the license of the 6 NGOs who were alleged to have used foreign contribution for religious conversion to ensure that such contribution do not adversely affect the internal security of the country. Recently, the NIA registered a case against a foreign-based group that provide funds for secessionist and pro-Khalistan activities in India. These regulations would enhance transparency and accountability in the receipt and utilization of foreign contribution. Controversies related to FCRA. Scope not defined, it prohibits the receipt of foreign contribution for any activities detrimental to the national interest or the economic interest of the state. However, there is no clear guidelines for the constitutes public interest. Limits for the fundamental rights. The FCRA restrictions have serious consequences on both the rights to speech and freedom of association under Article 19(1)(a) and 19(1)(c) of the Constitution. Way forward. Excessive regulations on foreign contribution may affect working of the NGOs, which are helpful in implementing government schemes at the grassroots. They fill the gaps where the governments fail to do their jobs. The regulation should not hamper sharing of resources across national boundaries, essential to the functioning of a global community, and should not be discouraged unless there is a reason to believe the funds are being used to aid illegal activities. So guys, that was all for today about the regulation on FCRA contribution. FCRA contribution was also amended in 2010. This act was formed in 2010 and which was amendment in 2020. So that was all for today. I hope you liked the video. Please do share the subscribe and comment down. Thank you.